Well, here we are again in the shade. You can hear the birds in the background, you can see the forest, the occasional butterfly, and you and me. What a combination. Well, today I'd like to talk about the proposed national emergency laws. And I think anybody who lives in Australia has learnt a lot of lessons over the last few days, I should say over the last few months, when they've seen the type of power that can be exercised by the state at a local and a federal level, where we see declarations of states of emergency, declarations of states of disaster, which override any implied rights. Not that there are many implied rights in the Australian Constitution. Now, I think historically we really need to look at what's been happening in our community in the last 20 years or 25 years, because I think most people have forgotten that these struggles have been carried out for decades, and they've been very, very important in the last 20 years, but unfortunately only a few of us have been involved in the struggles to actually explain what the laws mean and explain the lack of constitutional protection in this country. We are the only Western power, that's right, Western power, that has really minimal constitutional protections for its citizens. It has no constitutional protections against the arbitrary exercise of state power, and the impending legislation is neither here or there. It will allow the federal government to declare a state of emergency for the whole country. But currently those laws now exist at the state level, and we saw the declarations of state of emergencies and state of disasters to deal with the COVID-19 pandemic, and obviously using the real fear that people have regarding the pandemic, we now see them moving to the next level in terms of increasing powers. But historically we need to just go back 13 years to the intervention, the Howard government intervention, when after a few shock jocks made outrageous claims about many Indigenous communities, what we saw was the federal government feeling that an election was in the air, feeling that they needed something, to whip up hysteria in the community, set up a military intervention into Aboriginal communities. And that occurred in 2007. And the National Racial Discrimination Act had to be amended in order for that legislation to go through. Now, we saw military forces enter peaceful Aboriginal communities and Torres Strait Islander communities around the country. We saw military forces theoretically going to these communities to provide services and maintain order and security. Now, last year, Mr Walker, a teenager, Wapari teenager living in Yamindamoo, was shot by a police officer who's currently facing trial. But the tragedy is about Yamindamoo is that the Wapari were the Aboriginal people, were the last official massacre occurred of Aboriginal people in 1928 at Coniston. And so what did the Wapari and the people living in Yamindamoo, and we're talking about 800 to 900 people, what did they get for the intervention? Did they get medical facilities? Did they get health care? Did they get assistance? What they got was a $7 million police station in their community. And that $7 million police station is connected to the intervention and Mr Walker's murder. Extraordinary when you think about it. At the same time, we've seen legislation put in place in Indigenous communities before it's then been extended to the rest of Australia. And it's always been put in place under the concept that we're doing it for their good. The introduction of the basic card occurred in Indigenous Australia. It has now been extended to the rest of the country. Think about it. The introduction of work for the dole occurred in Indigenous communities over 20 years ago and now is a constant feature of our so-called social security system. So we see over and over again government using its power, unrestrained power, in order to maintain order, what it considers to be order, within various communities on the Australian continent. And this new legislation is nothing new. I know everybody's jumping up and down about the federal government having that power, but they've had that power for a long time. Legislation's gone through Parliament at the federal level and the state level on a number of occasions, over 100 occasions in the last 25 years, which have removed what few rights and liberties you think you enjoy in this country. Because the reality is, we don't have any rights and liberties. The only rights and liberties are those rights and liberties which the government of the day allows us to exercise. There is no protection. Legislation in both houses of Parliament can remove any rights and liberties you think you have. Over 25 years ago, the High Court found constitutionally the federal government had the power to detain asylum seekers and refugees indefinitely. It was constitutional. 20 years ago, the High Court found that the Australians had an implied right to freedom of speech only during the election period, because you couldn't have an election without people being able to exercise the ideas that they wanted to put forward to the population. So things move on slowly, but there is legislation in place to deal with everything. For example, at the federal level, if you're a member of the CFMMEU, the Construction, Forestry, Mining, Maritime and Energy Union, you have less legal rights than a drug importer who's found with $2 billion of cocaine. Because you have to answer questions. And these are questions about meetings. Who attended meetings? And if you don't answer those questions, you can be fined and imprisoned. And there are a number of cases currently dragging through the courts on this basis. Then you have the ridiculous situation of the Australian Broadcasting Corporation employees facing prosecution because they let the Australian people know about the atrocities that will be committed by the Australian Special Forces in Afghanistan on behalf of the Australian people. And 4 years later, after a preliminary investigation, most of these allegations have now found to be right. But these ABC reporters continue to face the threat of prosecution. Then we have the ridiculous situation of Witness K and Kaleri case, where the federal government has been conducting secret trials against these two people because they had the audacity to leak information to the media that the federal government in Asia was bugging the cabinet room of East Timor in order to gain a financial advantage in their negotiations regarding oil in the Timor Sea. So these things happen constantly. And if you think we all have equal rights, we don't. Look at Aboriginal and Torres Strait Islander communities, look at members of the CFMEU. Then look at all the legislation that's been brought into place in the last 25 years in order to destroy what's left of the trade union movement in this country. Legislation which basically outlaws the right to strike in this country. You can only strike during a limited period during an enterprise bargaining agreement, and then the federal court can overturn that right, although the members may have voted to take 4 hours industrial action, as we've seen in a recent case. So we've got all these laws in place which could not be in place if we had constitutional protections. And it gets worse. The Attorney General, Mr. Christian Porter, is coming under a little bit of scrutiny lately because of allegations regarding his personal life, which I'm not particularly interested in one way or other. But I am interested in the fact that these allegations are headline news. Well, when legislation was passed 20 years ago, which gave the Federal Attorney General the power to ban any organisation he or she felt posed a threat to Australians' interest, unilaterally ban any organisation, and gave them the power to jail up to 25 years any member of that banned organisation who continued to claim they were part of that organisation, and jail up to 25 years any person who raised funds in order to help their legal defence. I haven't made this up. This is not North Korea, it's Australia. I mean, we talk about the Chinese Communist Party and what they're doing in Hong Kong, but we never talk about the legislation which has been enacted, which can be brought forward at any time if you and I are involved in political, social and cultural activity which disturbs, not threatens, but disturbs the status quo. We have the ridiculous situation, and we've seen it enacted, where people can be arrested and held incognito for up to 7 days because they inadvertently may have information which may assist the authorities in their investigations. And we've seen that legislation used over and over again. And if you refuse to answer questions, you can be jailed for up to 5 years. So the list goes on and on. So these new emergency powers is interesting because it would allow the federal government not to rely on state governments to declare a state of emergency. Obviously, governments today say they need these powers in order to deal with bushfire threat, in order to deal with natural disasters, in order to deal with earthquakes, in order to deal with pandemics. We can deal with these situations without this overriding legislation, which is primarily enacted in order to criminalise and contain dissent. The tragedy is that 99.9% of Australians are not aware of the extent of this legislation. And every time legislation is passed like this, whether it's the intervention, whether it was the basic card, and the list goes on and on, people think it does not relate to them. Ultimately, it relates to each and every one of us, because laws are not passed in this country just to deal with specific subgroups. They have an impact on everyone. They may be enacted initially to deal with one section of society, but ultimately they affect each and every member of society. And it was quite interesting to see how the police, especially in Victoria, were actually able to implement those policies overnight with the full protection of the state and the full protection of the law. The dilemma is that if you don't have rights, then the government of the day can do what it likes if it has a majority in both houses of parliament. And we see that all over the world. I mean, the difference between a representative democracy where there are no constitutional protections for the individual, no freedom of association, no freedom of movement, the difference is minimal. And a dictatorship is minimal. And that's ultimately what the COVID-19 pandemic, I think, has actually taught so many people, that the state has an extraordinary amount of power, and has an extraordinary amount of power in this country because of the lack of constitutional protection. So what can we do about it? It's all very well for me to carry on over the last 2 to 3 decades regarding the whittling away of what minimal rights and freedoms we have. But the reality is, the first thing we need to do is actually let people know what's happening. Let people know it's not about Mr. Porter's behaviour regarding young staffers in his office. It's more about the power Mr. Porter has over you, where he can ban any organisation he likes at any time without going to Cabinet, without going to the Prime Minister, because he believes they may pose a threat to Australia's interests. So we need to look at these things, and we need to explain what the legislation is all about. And if we can create that climate where people begin to understand that the legislation is not just aimed at minorities, whether it's asylum seekers and refugees with indefinite detention, whether it's Aboriginal and Torres Strait Islanders with the military intervention. But this legislation is aimed at everybody. For example, we have legislation which indemnifies any police or military when a state of emergency is declared from any legal action at any stage for any of the actions they carried out. Now they're talking about setting up a prosecuting attorney to look at prosecuting members of the SAS who are involved in extrajudicial murder in Afghanistan. But there's no talk in this country about this legislation which indemnifies people. Not only does it indemnify the local police and the Australian military apparatus, it also indemnifies any foreign troops that are in this country at that particular point in time who will be used to quell any unrest or strike or uprising. And let's not forget there are over 3,000 United States troops based in Darwin currently, and there are many bases, US bases in this country, which play a pivotal role in the US military industrial complex. So we need to think about this, and that's the thing about Eureka, which is going to occur on the 3rd of December, the 166th anniversary. I mean, Eureka fundamentally was not a revolt about licences, mining licences. It was a revolt about fundamental human rights and liberties. The people involved in the Eureka Rebellion believed they were born with inalienable rights which no government or authority or private entity could take away. And when we find ourselves with our back to the walls, as we are currently, I think it's important that we remember the elements in the Eureka Oath. We swear by the Southern Cross to stand truly by each other and fight to defend our rights and liberties. Nothing encapsulates that struggle for freedom of movement, freedom of association, freedom of speech, freedom to strike, than the sentiments that were sworn in the Eureka Oath on the 29th of November 1854 by men and women who paid the ultimate price for their resistance. Not men and women who went to World War I to fight for the glory of God, King and country, not for freedom or democracy, but men and women who 60, 70 years earlier were involved in a struggle to ensure that those few rights and liberties we continue to be able to exercise in this country continue to be exercised. Next week, who knows, maybe I'll talk about the lint in my belly button.